And sometimes, where the thing itself has its rise from the law of nature, the particular circumstance and mode of doing it become right or wrong, as the laws of the land shall direct. Thus, for instance, in civil duties, obedience to superiors is the doctrine of revealed as well as natural religion. But who those superiors shall be, and in what circumstances, or to what degrees they shall be obeyed, is the province of human laws to determine. And so, as to injuries or crimes, it must be left to our own legislature to decide in what cases the seizing of another's cattle shall amount to the crime of robbery, and where it shall be a justifiable action, as when a landlord takes them by way of distress for rent. Thus much for the declaratory part of the municipal law, and the directory stands much upon the same footing. For this virtually includes the former, the declaration being usually collected from the direction. The law that says, "Thou shalt not steal," implies a declaration that stealing is a crime. And we have seen that, in things naturally indifferent, the very essence of right and wrong depend upon the direction of the laws to do or to omit it. The remedial part of a law is so necessary a consequence of the former two, that laws must be very vague and imperfect without it. For in vain would rights be declared, in vain directed to be observed, if there were no method of recovering and asserting those rights, when wrongfully withheld or invaded. This is what we mean, properly, when we speak of the protection of the law, when, for instance, the declaratory part of the law has said that the field or inheritance which belonged to Titius's father is vested by his death in Titius, and the directory part has forbidden any one to enter on another's property without the leave of the owner. If Gaius after this will presume to take possession of the land, the remedial part of the law will then interpose its office, will make Gaius restore the possession to Titius, and also pay him damages for the invasion. With regard to the sanction of laws, or the evil that may attend the breach of public duties, it is observed that human legislators have for the most part chosen to make the sanction of their laws rather vindicatory than remuneratory, or to consist rather in punishments than in actual particular rewards, because in the first part the quiet enjoyment and protection for all our civil rights and liberties, which are the sure and general consequence of obedience to the municipal law, are in themselves the best and most valuable of all rewards. Because also, were the exercise of every virtue to be enforced by the proposal of particular rewards, it were impossible for any state to furnish stock enough for so profuse a bounty. And further, because the dread of evil is a much more forcible principle of human actions than the prospect of good, for which reasons, though a prudent bestowing of rewards is sometimes of exquisite use, yet we find that those civil laws which enforce and enjoin our duty do seldom, if ever, propose any privilege or gift to such as obey the law, but do constantly come armed with a penalty denounced against transgressors, either expressly defining the nature and quantity of the punishment, or else leaving it to the discretion of the judges, and those who are entrusted with the care of putting the law in execution. Of all the parts of a law, the most effectual is the vindicatory, for it is but lost labor to say, "Do this," or "Avoid that," unless we also declare, "This shall be the consequence of your non-compliance." We must therefore observe that the main strength and force of a law consists in the penalty annexed to it. Herein is to be found the principal obligation of human laws. End of section 6. Legislators and their laws are said to compel and oblige. Not that by any natural violence they so constrain a man as to render it impossible for him to act otherwise than as they direct, which is the strict sense of obligation, but because, by declaring and exhibiting a penalty against offenders, they bring it to pass that no man can easily choose to transgress the law, since, by reason of impending correction, compliance is in a high degree preferable to disobedience, and, even where rewards are proposed as well as punishments threatened, the obligation of the law seems chiefly to consist in the penalty, for rewards, in their nature, can only persuade and allure. Nothing is compulsory but punishment. It is held, it is true, and very justly, by the principle of our ethical writers, that human laws are binding upon men's consciences. But if that were the only or most forcible obligation, the good only would regard the law, and the bad would set them at defiance. And, true as this principle is, it must still be understood with some restriction. It holds, I apprehend, as to rights, and that, when the law has determined the field to belong to Titius, it is matter of conscience no longer to withhold or to invade it. So also in regard to natural duties, and such offences as are mala in se. Here we are bound in conscience, because we are bound by superior laws, before those human laws were in being, to perform the one and abstain from the other. But in revelation to those laws which enjoin only positive duties, and forbid only such things as are not mala in se, but mala prohibita, merely annexing a penalty to non-compliance, here I apprehend conscience is no further concerned, than by directing a submission to the penalty, in case of our breach of those laws, for otherwise the multitude of penal laws in a state would not only be looked upon as an impolitic, but would also be a very wicked thing, if every such law were a snare for the conscience of the subject. But in these cases the alternative is offered to every man, either abstain from this, or submit to such a penalty, and his conscience will be clear, whichever side of the alternative he thinks proper to embrace. Thus, by the statutes for preserving the game, a penalty is denounced against every unqualified person that kills a hare. Now this prohibitory law does not make the transgression a moral offense. The only obligation in conscience is to submit to the penalty if levied,